Clients will often say to me, I love my kids. I want to support my kids. But what I don't want to do is pay my child support to her, because she goes down to the poker machines and spends the money on the pokies, not the kids. Or I don't want to pay it to him because he goes down to the TAB and spends the child support on horse racing, not the children. Is there anything you can do about that? And the answer is yes, there is. It's called the Child Support Substitution Order. And that's what I'm here to talk with you about today. I like to start these short videos with an excursion into legal history. Now, it's not a waste of time. I think it's important for my clients and for viewers generally to know that the troubles and frustrations they're experiencing have been experienced by people throughout history. Also, when I'm in court, I find a judge is far more prepared to accept the submissions that I'm putting to him or her if I can back them up with a bit of legal history. Most magistrates and judges have very little understanding about child support, and if you can point to a string of cases in the past where judges have done what you're asking this particular judge to do, they're far more reluctant to make the orders in question. Now, the Child Support Substitution Order. Throughout the history of the law, men have always been, and generally it is men who have paid child maintenance or child support. Men have always been able to provide what we call in specie child support, or providing goods and services as well as money for the support of their children. It might be the man paying the medical fees or the man paying the school boarding fees, whatever. Child support and child maintenance is not just about paying cash to the other parent and the other parent being able to spend that cash with impunity. Now, the case of Lily from 1960 is a good example of that in terms of legal history. It's reported at volume 1960 of the English Probate, Admiralty and Divorce Division Reports. It's a decision of the English Court of Appeal, and those who are prepared to take the trip to the local law library will find it reported at page 158. Now, in that case, the English Court of Appeal made the point that this provision of child support in an in-kind way or in an in specie way, or the modern terminology is by way of substituted child support, can be traced back through English statutes to 1895. And in fact, as a common law doctrine, English law has recognised it back to about 1630 is about the first reported case I can find. Now, the modern law is to be found in the Child Support Assessment Act of 1989, and in particular Part 7, Division 5 of the Act. And the Act, if you read it, encourages people to make applications to the court for these substituted child support. When making an application to the court, it's always a good idea to have modern court precedent as well as ancient court precedent. Judges, moderately interested in the fact this doctrine goes back to about 1630, but they want modern precedent if they're going to be persuaded to make an order. Perhaps the most useful modern precedent in terms of substitution orders is a case called Zepitovsky. It's reported at volume 14 of the Family Law Reports, and again, those people prepared to go along to the law library will find it's reported there at page 895. That was a case where a man was allowed to pay his child's school fees, which at the time were $2,500, and that was in complete cancellation of a year's child support payments. He was assessed by the Child Support Agency to pay about $2,500 per year in periodic child support. He went to the court and said, look, I'm paying these school fees. Can you discharge my ongoing debt to the Child Support Agency? The court said yes. Very, very useful concept to have. This has only been a very short video. Anyone interested in finding out more about the substitution order in child support practice should have a look at my website, childsupportlawyers.com.au. I'm Simon Bacon. I was a child support lawyer for 35 years, and I look forward to speaking with you in my next video.